Oh,
Thank you.
thank you, Derek. Thanks everybody for joining. This is our last session, our last conversation in the Conversatory of Racism Part 1. So yes, there's gonna be a part 2 and it's gonna be as great as this one. So it is my very big pleasure to introduce Marti Carcieri. We're gonna talk about the Constitution and race, a topic that it is as old as it is current, present in this country, still being discussed. So there is a timeliness, to discuss these issues. Marty, thank you so much for being here. You know that we're gonna have a conversation, and at the end, people are gonna ask questions through the Q&A. As Derek said, I encourage people to use the chat function to exchange comments, ideas that you may have. And now, Marty, thanks for being here.
Thank you for inviting me.
So let's jump right to it. Let's do like a little bit of rewind to the beginning, to the very start, and talk about the original Constitution and the Bill of Rights and the compromise with slavery that was at the very inception and creation of this country. If you can talk about, the articles that dealt with slavery and how that was so, it would be great.
Surely. Yeah, okay. All right. I appreciate everybody's interest today. This is a perennial subject, and so it's good we refresh ourselves on, where we've come from. Oftentimes in subjects like this, it seems to me that a fair place to begin is 1776. Yeah, with the Declaration of Independence. Now, that was not law. It was just a Declaration of Independence. But once the colonies declared independence, they immediately had to turn to some form of collective governance. And so in 1777, they drafted and agreed to the Articles of Confederation, which were the first attempt at collective governance of the new colonies. Well, by the middle of the 1780s, it was pretty clear to leaders throughout the colonies that the Articles of Confederation were not working. Basically, they did not put enough power into a central government. They kept too much power kind of out in the colonies, and it was recognized by the mid-1780s that we need to have a stronger central government. And so in the summer of 1787 in Philadelphia, the delegates from the different colonies came together, and under the leadership of a genius by the name of James Madison, they drafted the U.S. Constitution. And as I say, the U.S. Constitution put a lot more power into a central government than the Articles of Confederation had done. The thing is, though, with respect to, our focus today, there was this issue of slavery. The northern colonies, many people in the northern colonies rejected slavery, but it seemed pretty clear that the southern colonies were not going to join any new union unless they could preserve slavery. And so I'll leave it to professional historians to make this judgment, but it seems to me that those who gathered in Philadelphia in 1787 only had bad options. One option was to reject slavery, as a result of which the southern colonies would not have gone along with the Union. And the original colonies would have split into at least two, if not more, separate countries. And the problem with that is that there were still these large, powerful European powers like Spain and France and the Netherlands that, might have seen fit to try to come in and take back over some of these colonies if they were not all united. And so they bit the bullet. They compromised on slavery. There were several provisions we can mention in passing in the original Constitution that clearly show a compromise with slavery. And so that's what they did. In order to make sure that they had the largest possible economic, political, and military union possible, right? All the colonies came together, or once they had 9 out of 13 that signed off on it, they were bound. And so that's how that started, in my understanding.
So can you please refer to the 3 articles that actually address slavery in particularly, and what they say, there was a compromise on slavery. And if we then go, you know, throughout, right, history and constitutional history and amendment histories, is like filled with compromises that have, you know, the Black populations and slavery at the very core. But if you can refer to the 3 articles and what they said explicitly and what this compromise was about, right? One had to do with how to count slave for representation and taxation. If you could elaborate on those.
Okay, surely. Let me pull it up here, the Constitution itself. All right. And again, I'm a philosopher, I'm a lawyer, and I'm a political scientist. I am not an historian, so I'll do my best here. You know, actually, there are probably 6 or 7 provisions of the U.S. Constitution that refer directly or indirectly to slavery. Some are a little bit more blatant than others. In the original Constitution, by the way, it's interesting that the word slave does not appear. All right. Well, a couple of them, for our purposes, are in Article 1, Section 9. Article 1 of the U.S. Constitution basically creates Congress. And one of the things that it does is put limits on the power of Congress. And so that's what Article 1, Section 9 is about. And so Article 1, Section 9 is called the Migration Clause. And it basically says that Congress cannot stop the international slave trade for 20 years. So Congress, under Article 1, Section 9, could not prohibit slaves from being imported into the colonies for another 20 years. So that's one. The one that I skipped, actually, though, it comes earlier, is Article 1, Section, where'd it go? Section, it's earlier in Article 1, Section...
the Clause 1, right?
Yeah, I'm losing it right now. Oh, I got it. Okay. For what it's worth, Article 1, Section 2, the 3/5 clause. The 3/5 clause is very early in the Constitution. It says, you know, representatives and direct taxes shall be apportioned within the states according to the respective numbers. And it refers in a little bit to 3/5 of all other persons. So the bottom line is that they were clearly referring to slaves, and slaves were to be counted as 3/5 of a person, both for representation purposes and for taxation purposes.
So you interpret that clause as meaning that slaves were 3/5 of a person, or actually that they were persons, but they were going to count as 3/5 for the purposes of representation and taxation, without which the southern state would have had way less representation, right?
Right, that's right, that's right. See, that's an interesting thing, persons. It does say persons in Article 1, Section 2, and yet we know that, you know, slaves were not considered persons, really, in the full legal sense, right? So there's a little bit of a quandary. But the point is, it's clearly the 3/5 clause is clearly referring to slaves. And the bottom line is that they count as 3/5 of a person, both for taxation and for representation. Another one, by the way, let me just mention one other here. I don't know that we want to go on great length about this, but there's another in Article 4 of the Constitution. Let's see, where did it go? It's called, the Fugitive Slave Clause. Article 4 of the Constitution deals with interstate matters and national state matters, right? And so it says, Article 4, Section 2, it originally provided, no person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Fugitive Slave Clause. Other states were bound to return fugitive slaves to their original owner upon request by the state. So the point is, that's clearly, I don't know if we want to spend a lot of time here, but one more example of how the original Constitution compromised with slavery. And again, it seems to me there were only bad options, which so often is what characterizes life. Yeah. Mar, did you want to say anything else about that?
So, yes, I mean, a little bit of a recap. So we have like 3 main points. I mean, there are other indirects, but one was Congress could not forbid slavery for the following 20 years. The
Right.
second one is the counting of the Black population slaves, not,
Yes.
I mean, not all the Black population, but the enslaved Black population as
Yeah.
3/5 for purposes of representation and taxation. So that was like the compromise, you know, the southern states, you know, the lesser evil, right? Like the compromise of the southern state to be part of the union. And third, even though, and this is my understanding, even though a federal government, right, was created, the federal government could not interfere, right, with the extraterritoriality of slaves, basically the extradition, right, of states. And the interesting part of this, I think, is that the bondage followed the person, but not the laws of the state. So whether you would just leave and go to a state where, you know, you would be free, you wouldn't, because it would follow you. So
Right.
wow. So that's at
Well
the
put. Yeah.
so that's at the very, very inception. So and then we have well, how states in the South crafted all the laws, Mississippi and Virginia. I think that we're going to go a little bit, you know, fast forward on that. Even though as early as 1833, I think there was this woman, Vivian Maria Child, who already said that citizenship should be granted on birthplace, right? Like if you were born here, like you should have the right to be free. And, you know, it was just 30 plus years for that to be the case. So let's move to Reconstruction.
Sure.
And after the Civil War, when the South kind of loses, I want to say, because it's unclear to me whether it lost or it didn't lose. And, you know, what happened there constitutionally, what was Reconstruction, what were the three amendments, and what the implications of them were.
Yeah. Yeah. Wow. Yeah. First of all, I lived in the South for 10 years. And in general, I like the people. I found that they were very friendly and outgoing, but I'm also here to tell you that there are people in the South who are still fighting the Civil War. Or more accurately, they call it the War of Northern Aggression. Yeah, that's how some people refer to it in the South. So that's right. That's right. You know, I think once the original Constitution compromised with slavery, I think a lot of folks thought that it would just die out on its own. But clearly it didn't. And so one of the main reasons for the Civil War was slavery. And that was a long, bloody war. I think it killed 2 or 3% of the US population. And there's a basic sense, I think, in which we still have not recovered from the Civil War. Okay, right as the Civil War was winding down in January of 1865, the 13th Amendment was proposed and ratified. And the 13th Amendment is one of the few amendments in the Constitution that speaks directly to substance as opposed to process, like, you know, expanding the number of voters, right? The 13th Amendment, 1865, banned slavery. It banned slavery and involuntary servitude. All right, so that was step one. And just as an aside, for those of you who are movie buffs, there was a movie about 10 or 15 years ago, I think it was called Lincoln. And Lincoln was played by one of the world's great actors, Daniel Day-Lewis. And I recommend that movie if, you know, just interesting on that account. Okay, so as you know, the Civil War basically ends in 1865, more or less. And then, so in terms of what we're looking at, it's 3 years later, the 14th Amendment, ratified in 1868, that has two of the most important provisions in our whole Constitution. One is the Due Process Clause, and that provides that no state shall deny any person life, liberty, or property without due process of law. Notice that there was already a due process clause in the Constitution in the Fifth Amendment, right, back in the Bill of Rights, but that only restricted the national government. The 13th, 14th, and 15th Amendments explicitly restrict states, right? So, so we've got that. And then ground zero within the entire Constitution for the litigation of, you know, racial discrimination is the Equal Protection Clause, also in Section 1 of the 14th Amendment. And the Equal Protection Clause provides no state shall deny to any person within its jurisdiction the equal protection of the laws. All right. So there's a few things to be said there, right? Equal protection does not guarantee equality across the board, does it? It simply guarantees equal protection of the laws that exist. And it should also be mentioned, and keep this in mind later when we get to the affirmative action stuff, it's important to recognize that, oh, I see, somebody's talking to me about the light, all right. It protects any person. And so equal protection is held by every person. It's very difficult to read group rights into the Equal Protection Clause of the 14th Amendment. So just keep in mind, that's going to be one of the big points of contention in the affirmative action cases going forward.
Right, but even if we can't, that's a very interesting point, and that would take us to like a whole detour, even though, you know, you cannot read group rights, right? I mean, you still can read equal protection of the law, and when you discriminate the law vis-a-vis groups, it's not equal protection. I mean, the Equal Protection Clause, I mean, there were several kind of Supreme Court suits, I mean, we can talk about this later, that precisely were filed under that particular clause, right?
Right. That's right.
So this is going to become an issue. I mean, I don't want to detour from the 15th Amendment, so we cover kind of the basics, but I mean, this is going to become an issue between the federal government and the US Constitution in those three kind of amendments, and, you know, the power that is delegated in this federation to the states, and how, you know, after Reconstruction, you know, they passed the laws that they passed, right?
Yeah, okay. Okay.
So, so you were saying 14th Amendment, you cannot read group rights.
Yeah, yeah. And then 15th Amendment.
Right.
So the Civil War amendments, 13th, 14th, 15th Amendments, all ratified within 5 years of each other. And, you know, historians have said, you know, this really was a kind of a new chapter in our constitutional history, right? One in which, after a bloody civil war, we put specific restrictions on the states. Okay, so the 15th Amendment guaranteed Black men the right to vote. So just we're clear about that. Women of any race had to wait another 50 years until the 19th Amendment. And as I'm sure we all know, this year marks the 100th anniversary of the 19th Amendment. So, okay, so those are the Civil War amendments themselves. I can talk a little bit about some of the legal landmarks on race since Reconstruction. Go ahead.
So let me ask you something, like, so we retake about, you know, the cases after Reconstruction, because it is my understanding that, and well, I'm a foreigner clearly, right? And the myth goes that, you know, the North fought this war about slavery upon ideals, right? It's a good North that wanted, you know, everyone to be equal. But that seems to be, I mean, there's a lot of historiography that is kind of reviewing that history, and without going into details, reviewing that history, that we can provide kind of references. But in the presidential election of 1877, it's my understanding that there was yet another compromise, right? Because the North was going to overlook the South in making sure that these federal, you know, amendments were going to be enforced at the state level. But that we know didn't happen. So what happened there?
Well, I'm not really prepared on that particular point. I'm not going to pretend that I have any expertise on that.
Right.
I know that that election was an important one, but I'm not going to pretend that I can speak with authority on it.
Right, because I mean, I said, like, what happened here? Like, basically, they arrived at another compromise, right? In which, you know, the South basically was left to do what the states wanted. And then we jumped to Plessy versus Ferguson. That is,
right,
you know, a landmark decision that I would super appreciate if you can instruct us about.
Yeah, Plessy v. Ferguson was 1896, right? And so, you know, this is a couple of decades after, you know, the election of 1876. And in Plessy v. Ferguson, generally considered to be one of the most infamous cases in our history, the U.S. Supreme Court upheld against constitutional challenge a Louisiana law that required separate railroad carriages for black and white passengers traveling in Louisiana. And the doctrine, I mean, the Louisiana law was challenged as unconstitutional under the Equal Protection Clause, but the court said, you know, this law does not violate the Constitution so far as the accommodations are equal. They can be separate but equal. So that was the key phrase that came there, separate but equal. And so Plessy v. Ferguson upheld blatant racial segregation in public transportation.
So to retake, to just to do some historical fillers, here we have like the full blown, if I may put it like that, the Jim Crow laws, right, that enforced before this racial segregation in the southern United States. Because the slavery economy, it's my understanding, that required, you know, closeness, right, between slaves and slave owners to actually secure, you know, that domination. So these laws are gonna go up to the civil rights movement. And these actually, what were the implications or effects of this Plessy versus Ferguson ruling of the Supreme Court in 1896?
Well, I think the effect was that for the next 60 years, states were free to still pretty much segregate as they saw fit. I think there were a number of little cases here and there that took this up, but I think it's fair to say that it was not until Brown v. Board of Education, 1954, when the doctrine of separate but equal was finally put to rest, at least in terms of Supreme Court precedent. So Brown v. Board, sure a lot of you realize, has been called the greatest U.S. Supreme Court ruling in the 20th century. And it held that racial segregation in the public schools violates equal protection. It was a landmark unanimous ruling, important to understand. Chief Justice Earl Warren, who was a very able, you know, politician, former governor of California, I think sensed that for such an important decision, it had to be a unanimous ruling. Otherwise, given the resistance to it, it may not be nearly as successful. And so, and God knows there was a lot of resistance to it. Some people will tell you basically nothing happened for the next 10 years until the 1964 Civil Rights Act. Mm-hmm. Yeah, that was Brown v. Board. Now, be clear, Brown v. Board was an equal protection case. And so, and we know that the Equal Protection Clause only constricts government and public institutions, right? It says no state shall deny any person the equal protection of the laws. That's why, in order to reach racial discrimination in the private sector, as opposed to the public sector of government and public institutions, it took a law like the 1964 Civil Rights Act to put some teeth into, you know, the command of non-discrimination.
So could you tell us more about, you know, the ruling, what was at stake? We were in separate but equals, and the federal government basically just turned the other way and allowed states to do whatever they were doing, even though it wasn't equal protection of the law, until 1954, right? Brown versus Board of Education. And what exactly was the lawsuit and the ruling, and what happened after that?
Okay. Brown v. Board actually was 4 consolidated cases. The U.S. Supreme Court considered them all together from different states, right? And there was actually also a challenge brought in there to racial segregation in the public schools in Washington, D.C. Mm-hmm. It's called Bowling v. Sharp, which actually, since the federal government is not technically constrained by the Equal Protection Clause, the court had to kind of shoehorn it in, right? And so it was, Brown v. Board was actually 4 cases that were consolidated. And again, the basic ruling was that racial segregation in the public schools violates the Equal Protection Clause. It's a remarkable ruling, and it's not very long. I do recommend it to people because it's got some linguistic analysis, it's got some historical analysis. It's not a real long opinion, and but you know, it gets the job done. And but there was a lot of foot dragging in the South, especially in the years following Brown v. Board, and so. again, like I'm saying, it was not until the early 60s, and it may even have taken the death of JFK for a very skilled politician by the name of Lyndon Baines Johnson to step up and provide the leadership to make sure that Congress passed the 1964 Civil Rights Act.
Right. So after the Brown v. Board of Education, it is my understanding that Warren replaced a judge, and he came like right at the right time to take over this case, because otherwise, it could have been different, the result. But then we have the Little Rock Nine, right? And even though that is not the Constitution, I wanted to refer a little bit to it, if you would like to elaborate, because, the federal government, right, stepped in, against the state.
That's right.
And that's something that has become more unusual than not in the US, despite, what amendments say, or am I reading it incorrectly?
Okay, hadn't really thought about this before. Yeah, I mean, I think what you're referencing is part of the agitation that was going on, after Brown v. Board, and the resistance to it for several years, right? I think between 1954 and 1964, there was very little integration. I mean, in the first few years, as far as I understand, Brown v. Board did not have a huge impact in terms of integration, So it took legislation like the '64 Civil Rights Act to really put some teeth into that principle. So I don't know. Yeah.
No, because
go ahead.
Because for me, that was a very interesting. That was, it was interesting that the federal government intervened, whereas in other instances in U.S. history, whether the law was on the side of the federal government, but the politics was not. To put it somehow, it didn't intervene.
Right.
Against the states. But the interesting point in these kind of gap years is that one thing is just segregation, that is, enforced discrimination by law. There is desegregation, that is the lifting of the laws that enforce that discrimination. But then there is integration that requires an intervention of the federal government to integrate. So I think that making this distinction between the three makes it, a little bit more encompassing in terms of the situations that were taking place and the kind of discussions and resistances that were going on. Because it is at the point of, Little Rock that basically the federal government not only desegregates by the ruling, but actually intervenes to integrate, right?
Sure. Yeah, I think if I take your point, I think it's an important point that really it wasn't just what the Supreme Court was doing. It was also about what the executive branch was doing. And I think it took a relatively strong president like Eisenhower to do what he did in 1957. But also, again, by the early 60s, you got Congress stepping up. So if your point, I agree with your point that, it's to really understand what's going on here, and we're all beginners with this, including me for sure, it's important to recognize what all three branches of the national government were doing.
So that takes us to 1964, right? The Civil Rights Act and then the Voting Rights Act. Would you elaborate on that?
Yeah, sure. I can say a little bit about it. The 1964 Civil Rights Act had a number of separate titles within it, right? So Title II of the '64 Civil Rights Act, for example, bans racial discrimination in certain places of public accommodations, like restaurants and hotels. Title VI of the '64 Civil Rights Act bans racial discrimination by entities that accept federal financial support. Kind of a give and take thing. If you want this money, you shall not discriminate. And then Title VII bans private employers that are engaged in interstate commerce from engaging in racial discrimination in employment practices. Mm-hmm. So about that is that with Title VII, we're not talking about restrictions on entities that are accepting federal money. It's just, if you're an employer and you're operating in interstate commerce, you shall not discriminate. It was a mandate, not just an offer of, money for not discriminating. So just as a little aside for those who are interested in these things, Congress had to rely on its power to regulate interstate commerce in order to pass the 1964 Civil Rights Act, right? I mean, the 14th Amendment, the last section of it gives Congress the authority to pass laws enforcing the 14th Amendment. The 14th Amendment, Equal Protection Clause, only restricts the states, the public sector. And so, again, clearly, the last section of the 14th Amendment could not have been relied on by Congress to enact the 64 Civil Rights Act. So it relied on its commerce power. And apropos, Mara, of what you were just saying, a very progressive, I don't know if that's the word that I want, relatively liberal Supreme Court in 1964 was more than happy to uphold Congress's power to pass the 64 Civil Rights Act based on its power to regulate interstate commerce. So,
because that wasn't, I mean, I don't want to say a loophole, but like another route in order to enforce these provisions that otherwise would have been very difficult to do, right? Because Congress, right, has the power to regulate interstate commerce. That's super interesting. And then we come, you know, of course, to 1965 and the Voting Rights Act, and what happens after that for me is fascinating, because we need to, I mean, everyone in the audience, you know, knows, but it still just blows my mind because I'm a foreigner or whatever, that it was the Southern Democrats that actually were upholding, you know, all these laws. And when they saw basically their grounds completely lost, right, in 1965, basically they moved gradually to Republicans, and many of them were, you know, the coalition that's supporting Reagan, you know, 15 years, you know, later. So I mean, I would.
Famous saying, LBJ, I think it was after the 64 Civil Rights Act passed, he said, "There goes the South." Apropos of what you're saying. So, yeah.
But that's not related to the expression going south, right? Because I feel offended.
I am not going anywhere near that one. God.
No, that's me when they're talking about like going south, you know, that's.
Yeah, all right.
Me. So I want to mention something like another, you know, thing after the civil rights, you know, just to cover the landmarks, because I really want to get to the Constitution in 2020, and we have, you know, a measure on the ballot in California that concerns all of us, and it would be great to tie it to all these discussions we're having. But there is a precedent. So we have covered, like, to do a little bit of like the history of this conversatory, you know, we cover institutional racism and implicit bias, and, you know, the unequal opportunities that, you know, Blacks, but not only Blacks, have been having from different angles. And, you know, a major one is constitutional in terms of access to, you know, the possibility of education, wealth, etc., etc. So all of this to say, there is another landmark case that is Baki, I think you pronounce it, versus the UC Regents in 1978, that is an appeal against affirmative action. Can you tell us a little bit about that?
Surely. Yeah, UC Regents, University of California Regents versus Baki, B-A-K-K-E. Landmark decision, really kind of the mother of all affirmative action decisions. UC Davis Medical School, which is one of the more selective medical schools in the country, had an entering class each year of 100 students, and it had many more applicants than there were seats. And so it decided to, a couple of years earlier, to set aside 16 seats out of every 100 in the entering class for individuals who were members of 4 racial or ethnic groups: African Americans, Hispanics, Native Americans, and Asian Americans. Well, Alan Baki applied twice to UC Davis Medical School and was twice rejected, even though he found out that his undergrad grade point average and his medical college admissions test scores were significantly higher than many of those who were admitted under the special admissions program. So Alan Baki brought suit, and he challenged the UC medical school special admissions program under the Equal Protection Clause. a fascinating case. You know, Justice Lewis Powell wrote the controlling opinion. And Justice Powell has long been a hero of mine. He's written a number of opinions that I think are just masterpieces. And in many ways, I think the Bakke opinion is one of them. He had to split the difference here. And basically what he said was the following. Although UC Davis cannot use such a blatant, set-aside program that violates Equal Protection Clause, in order to advance student body diversity, what the medical school can do is to take race into account as one of many factors to tip the balance in close cases between otherwise equally qualified applicants. Kind of set this, this process on a new footing. So again, in order to achieve the goal of diversity, that goal, the means that institutions may use to advance that goal is to use race as one factor among many to tip the balance in close cases. And so that's what that case ruled. I invite anybody to, who's really interested, to take a look at the Bakke opinion. The whole thing is like 200 pages long. And there are other, dissenting and concurring opinions, but
it was a pluralist opinion, right? The Bakke one.
Yeah.
Could you explain what
plurality.
that is? Because it's not plurality. How do you call it?
Plurality. A plurality.
Plurality opinion. It's interesting because in other conceptual horizons by different thinkers, plurality means something completely different than what a plurality opinion means, which is basically that you didn't have, a full majority, right? That you have like the most numbers of concurrent opinions, but none to make it to the majority.
Yeah. It's interesting. It's a splintered opinion is what it is. And, there was a majority, Powell and the liberals, with respect to the holding that race can be used to advance a compelling state interest like student. But beyond that, they didn't agree on a whole lot. And so again, the opinion by the liberals is something to see, Brennan, Marshall, and all of them, and then by the conservatives is quite something to see. But Justice Powell's opinion was the controlling opinion. And so, and it's important to note in passing that insofar as a public institution was using race, in the admissions program to allocate public benefits, that triggered what's called strict scrutiny. Most skeptical level of scrutiny that the court uses to examine challenged laws that are challenged under the Constitution. And so the UC Davis special admissions program did not survive strict scrutiny. It was struck down. But again, explain that race can be used in a much more limited way to advance the goal of student body diversity, whatever that means.
So I am so glad you made that final comment, because it is the whatever that means that is crucial, and it's at stake right now, and that opens up another universe of conceptual and political discussions. But what it also does, it is my understanding that it kind of strikes down the use of quotas, which is going to bring us to some of the arguments that were made in against Harvard, but we'll get to that. But before that, I think that the issue of diversity is an important one, because on the one hand, it can be considered as a desirable goal, right? And it has been proven in business that it is a desirable goal, that it enhances the experience on everybody. But that, in a way, waters down a little, right? Or diminishes, the structural disadvantages that, mostly Blacks, but other groups have had in this society. Because what counts as diversity, right? Diversity is not the same as to acknowledge that, Black people were enslaved and they didn't have equal opportunities, or Latinos, or everyone. But I know that it opens up, a whole another discussion that would just go over the time and the topic that we have. So with these precedents, let's come back to the present, even though this is very much the present, right? Because these issues that not only are we still discussing, but as concerns, but are very much part of our daily political reality and on the ballot in California in November. So I wanted to ask you about Prop 209, its effects, its repeal, and if we can refer like a little bit to the challenge by Asian Americans, you know, to race-based admission in Harvard, taking into account that Harvard is a private institution, so you know it's not the same as
Right.
as the laws that we have been discussing.
Yeah, yeah. Okay, yeah, there's really two lines there, right? On the one hand, you know, Prop 209 has to do with what public institutions can do with respect to race. The lawsuit by Asian Americans against Harvard is not a constitutional case, right? Government. It's a Title VI case. Remember that from the 1964 Civil Rights Act. Since Harvard accepts billions of dollars in federal support, grants, and so forth every year, like just about every other, you know, private university, it is bound by Title VI, which says that any institution that accepts federal funds shall not discriminate against any person based on race, gender, ethnicity, national origin, so forth. So, so two separate things there. They're sufficiently different that I'm not sure that the Supreme Court would consolidate the two when it eventually hears them. So we'll keep Asian American versus Harvard in one place. By the way, folks should know that a federal trial court, a federal district court in Boston has already ruled on the Asian American versus Harvard case, and it ruled in favor of Harvard. So that case is now going to be on appeal to the First Circuit Court of Appeals in Boston. And I don't think it's too much of a stretch to say that however that intermediate appellate court rules, the US Supreme Court may very well weigh in on this case. And so that's
yeah, a lot of people see that happening, and a lot of people are claiming that Clarence Thomas would have like a lot of pleasure of striking down affirmative, you know, action.
Yeah, Donald Trump has significantly, you know, reformed the court in this sense, and so we can come back to that. The other thing you say is Proposition 209, and I think folks who are old enough to be members of the Fromm Institute will remember 24 years ago, Proposition 209. Proposition 209, of course, was a citizens ballot initiative in California, and it was approved, and so therefore became Article 1, Section 31 of the California Constitution. And it provides as follows. It says the state shall not discriminate against or grant preferential treatment to any person or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. So that's what that provision of the California Constitution says. And as everybody knows, there's a move on, there's an initiative on the November ballot to repeal Prop 209. And so I have to say, based on what I'm seeing, I would not be surprised if Californians repeal Prop 209. And although at that point, I would be surprised if there were not a challenge to that repeal under the US Constitution, under the Equal Protection Clause, the 14th Amendment. So the bottom line is that I think there's a very good chance that the US Supreme Court will be hearing that case as well.
Wow.
Years. And what makes it particularly interesting and vexing is that with Prop 209, Californians made non-discrimination the actual policy of their law. There was already an equal protection clause in the California Constitution, but that was, you know, in the judgment of many, not being enforced. And so Prop 209 made race and sex and national origin non-discrimination against any person, the actual policy of California law. And
what it did,
you know, it looks like it may get overturned. So that'll be, go ahead.
no, what is, what's mind-blowing about, you know, Prop 209 is that because it was, first of all, it was proposed by one of the regents, Connolly was his name?
Ward Connerly, yes.
Connolly was his name. So that's one number one. But also in terms of, it's not only non-discrimination, but I think that the most important part of that is like no special treatment, right? Because as you mentioned, you know, there was equal protection, you know, before that in the 14th Amendment. So you have like no discrimination, nor, you know, preferential treatment. And a lot of people think about, you know, Prop 209 in terms of mostly Black Latinos, kind of admissions in universities and public institutions, right? But it is race, color, ethnicity, gender,
Yep.
gender, national origin, not only in public education, but in public contracting,
Yes.
in public employment. This has had like a devastating effect on women, for example, and businesses and application for, incentives in business. It's major in terms of what it has prevented. And we can look at number. People usually look at numbers in kind of university admissions, right, and graduation. But it goes beyond that in terms of business, opportunities as well.
Okay. Okay. Yeah.
So the repeal is going to take the form of ACA 5, and it's going to be on the ballot. And actually the wording of ACA 5 is just crystal clear on all these issues. I mean, it's something unlike others, because I'm not a lawyer. It's kind of very easy to read.
Yeah. I don't have it in front of me, but I understand it's there to repeal Prop 9, Article 1, Section 31 of the Constitution. So,
and it's a good listing of like all the reasons in terms of, not only kind of like admissions, but, businesses, gender, etc. So I'm going to jump like in a complete non sequitur, because you have written a very interesting article. Not that you have written only one interesting article, but an interesting article on Rawls. I don't know whether people are familiar with John Rawls, a political theorist who wrote a book in 1971, A Theory of Justice. And given these inequalities, like outrageous, if I may add, inequalities as a result of slavery and economic interests, and also, moral positions of different parties, in the US, there has been discussion for a long time about reparations for the Black population, right? And on which basis, for whom, looking towards the past, looking towards the future. And you, Marty, you wrote an article with a justification for reparations in a very particular way, based on John Rawls, and I would be grateful if you could share that with our audience.
Surely, in general, it's a very dangerous thing to ask a scholar to talk about his published work, because if you're not careful, he'll tell you. You see, and then you'll really be sorry. Right? But you did it, so here we go.
I'm glad I did.
Yeah, John Rawls was maybe the most influential American political philosopher of the 20th century. He published, as you say, a book in 1971 when he was 50 years old called A Theory of Justice. And that's the most widely cited book in political theory since John Stuart Mill wrote in the mid-1800s. And I think I can put it in front of people basically this way. I'm going to say that a great philosopher like Socrates asks questions, asks the right questions, asks powerful, disturbing, earth-shaking questions, like what is justice? What is virtue? What is a good human life? And by the way, Socrates asked, isn't democracy the worst possible form of constitution except for tyranny? So, but, they put him to death. So, he came to his end. But if a great philosopher asks the right questions, I'm going to say that a great political theorist like Plato or Machiavelli gives answers. I'm going to say that John Rawls did both things. So he asked a really interesting question. He said, what would rational, reasonably self-interested individuals equally situated behind a veil of ignorance about the details of our own lives agree to as the basic principles that will ground our constitutional order once we know who we are, once we know what the details of our lives are? So what would we agree to? It's a social contract theory. As a matter of contract, what would you and I agree to as the basic principles that will govern us, in the absence of knowing who we are in particular? See, I can tell you what perfect justice would be, right? I mean, Rawls is good, but perfect justice would be all political and economic power concentrated in the hands of Italian-American men, about 5'10", about 160 pounds. You see where I'm going with that? If I already know who I'm going to be, hey, justice is I have all the power. But the great thing about what Rawls is asking about, building on earlier philosophers, is what if you didn't know your race, your ethnicity, your gender, your wealth, your health? All you know is you're going to show up as somebody in that society. And without knowing the details of your life, what would you agree to as the basic principles? And insofar as that's what we would agree to, not knowing our particular advantages and disadvantages, the terms of that agreement are fair. We agree with them in an initial situation of fairness. So what are the two principles that he says and argues that we would agree to? The first one is called the equal basic liberties principle. You know, each person is to have a equal right to the most extensive total system of equal basic liberties compatible with a similar system of liberty for all. So equal basic liberties. Political liberty is not licensed to do anything that you want. Everybody understands political liberty has limits on it. You know, your right to swing your fist ends where my face begins, right?
Mhm.
So political liberty is necessarily limited, but the basic rule we would agree to is all of us have equal basic liberties.
And you know, to point to this that is very important is that there's a strong principle of reciprocity there, right?
Yeah,
in the
exactly
idea
right.
of liberty, even though liberty is the priority,
Yes,
it's not an individual liberty without the dimension of reciprocity, which is what you
exactly
were
right.
pointing to.
Contract, that's right.
And the second principle.
Yeah, I want to, you raise a very important point. Contract, social, mutual advantage, reciprocity. You're absolutely right. So that's the nature of it. What would we agree to, right? So the second, so the equal basic liberties seeks to guarantee equal basic liberty in the political and legal spheres. And I would think all people of good intention can agree to that, right? As a political matter, right to vote, freedom of speech, right? We should all have equal basic liberties, right? So on the other hand, though, and this may be a real challenging point for some people, but I'm going to suggest this, and Rawls does basically say this, right? In any relatively free society, there will be some measure of social and economic inequality.
Mm-hmm.
Any free society, there will be some measure of social and economic inequality. Let us strive to ensure equality in the political and legal spheres, but socially and economically, some people are just going to do better than others, right? And so that's where the second principle comes in. It's called fair equality of opportunity. Here, Rawls writes, the principle we would agree to is that social and economic inequalities are to be attached to offices and positions open to all under conditions of fair equality of opportunity. Now, as a Rawlsian liberal on the center left of the political spectrum, I tend to think that conditions of fair equality of opportunity would basically include inexpensive education for all and inexpensive healthcare for all. After that, you're kind of on your own. And so if Rawlsian principles of justice were embedded in our law going forward, I would think that the big Trump-McConnell tax cut would be about to be reversed. And you know, my students at San Francisco State would have to pay maybe 1/10 of the tuition that they have to pay in order to get an education. I think they should have some skin in the game, you know, it shouldn't, when young people get something for free, they tend not to value it as much, you know, but still the amount of money that people have to pay to go to the CSU or the UC is, you know, I think a lot of people can agree probably too much just to get a basic education. But
unless there's a strong principle of reciprocity, but I don't want to just enter into like a full political theory kind of normative discussion. I want to lay kind of the grounds and just jump right because I want to be fair with people who like are already sending questions.
Yes.
So would you talk about the difference principle, the worse off, and how that would play vis-a-vis reparations?
Okay, boy. All right. Now that's just capture all of that very quickly. Because my argument, let me just tell people my thesis, right? My argument is that while strong forms of affirmative action cannot be derived from Rawlsian principles, strong forms of legislative reparations directed at the least advantaged communities can be derived from Rawlsian principles. And so, you know, Rawls speaks the difference principle. As I'm sure you know, Rawls situates that after equal basic liberties, those come first, and then fair equality of opportunity for each person. That comes second. And then after those are satisfied, then the difference principle provides for extra care to be taken for those who are among the least advantaged groups. And Rawls, this may be controversial, Rawls defines least advantage in terms of wealth and income. Take the view that if the only thing you know about a person is their race or gender, you do not know whether that person is among the least advantaged. Go ahead.
No, I wanted to point to that I mean, the least advantage is an economic. I mean, he sets a priority between, the political first, basically basic liberties, that takes over kind of the economic, which like this second principle with these two clauses, relate to. But basically, under the veil of ignorance, you do not know who you are going to be. And the fact that you're rich, woman, or whatever color of your skin doesn't make you morally better and therefore worthy of receiving kind of more, right? So there's no group adscription that should allocate anything. Kind of that's a negative principle, but the positive one is basically to allocate, taking into consideration the least advantage. I mean, an analogous thing to think about is, you are as happy as your saddest child, right? I mean, it's not the same, but that's the spirit. Like when you live the one that is at the bottom, this is, what you should be looking at as a measure of a fair society. So what would, how would reparations look like? How would you allocate?
I love that line. I never heard that before. You're as happy as your saddest child. Okay.
I promise you that's the way it is.
I get that. Yeah. I don't have kids, but I have a wife. And so I certainly can appreciate the idea that if your wife is not happy, there's only so happy you can be. Right? So,
do you have cats?
I do. I do have cats.
So,
well, reparations, the way that I define it, the reparations that I think could be derived from Rawlsian principles would be that, again, even though strong forms of affirmative action cannot be derived from Rawlsian principles, reparations, right? Legislative reparations, I want to be clear about this. As I defend them, they come from the legislature. Judges do not give reparations as in a lawsuit. That's not it. It's legislative reparations, and that would be resources devoted to community-based organizations in the least advantaged communities. And again, least advantage for Rawls is terms of wealth and income, but as Mara, you've already indicated, to a great degree, that's going to overlap with race and ethnicity in some places. But we target communities, the least advantaged communities. And so maybe the legislature would allocate extra funds so that there are extra programs for public school kids in less advantaged communities. Maybe they can have smaller classes, higher teacher-student ratio.
But that is, I want to make this point, but this is because for sociological and historical reasons and not for racial reasons, right?
Yes.
And with that would entail is that, if I may spell it out, right, poor white communities, right, would also be recipients of these, reparations, which brings the concept of reparation to a very particular and controversial for many kind of level. But I wanted to put it out there because, people, certain people are talking about, this, I think it's like the 17 trillion billion of dollars that, the government of the US owe the Black population, given, how, they build the country for free. How would that be allocated? Others like Len Lurie say, you can look at the past, but you also have to look at the future. You're going to, offer reparations, but if you do not provide for like a flow of income, those reparations may go without actually building and supporting wealth. And there's a further argument of reparations about, the symbolic and moral recognition of the damage made. So I don't know whether I would agree with you that I would call that reparation, right? but that's an interesting discussion that I want to leave, you know, there. Is there anything, any closing comment? Oh, not closing. We're going to open up the questions, but is there any further comment you want to make on this, Marty?
No. Yeah, no, I think we covered a lot of ground, and yeah, no, I appreciate you know, your efforts here, and I'm glad to hear any questions that folks have. I cannot promise I'll be able to answer everybody's questions, but I will do my best.
I thank you so much. This has been like super rich, and of course there were like way more things to discuss. I encourage people to register for our discussion sessions that are small and intense at times, and they have proven really, really good for everyone participating. So let me go to the questions. We have Jonathan Marsh asking, what is the basic reason the 10th Amendment has been able to be used to justify limits on the Civil War amendments, which were aimed at limiting state powers?
Yeah, interesting question. First of all, the 10th Amendment, which is ground zero in the Constitution for states' rights, right? Again, I lived in the South for 10 years, and I met a lot of folks who are still fighting the Civil War, and they see almost nothing in the Constitution except the 10th Amendment. The 10th Amendment, one of the original Bill of Rights, ratified in 1791, provides that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So a little bit of context there, you know, as we know, Article 1, Section 8 lays out the great powers delegated to Congress, you know, to tax, to regulate interstate commerce, to spend, and so forth, right? So the powers not delegated by the United States by Article 1, Section 8, nor prohibited by it to the states. Article 1, Section 10 puts a number of limitations on the states, and so that's the reference there. So powers not delegated to the U.S. nor prohibited by it to the states are reserved to the states respectively or to the people. So the 10th Amendment basically stands for the idea that those powers not given to the national government and not denied to the states remain with the states.
Mm-hmm.
And very much, you know, a states' rights foundation in the Constitution. Now, the question was with respect to, I'm sorry, with respect to what? Some of the later
right. Why actually that 10th Amendment was used to justify, you know, limits on the Civil War amendments, as we have, you know, mentioned earlier, is like a strong argument, you know, actually constitutional argument on federal powers on the states. I'm elaborating on the question, and I hope I'm making justice to the question. And how is it that, you Tom, the 10th Amendment can actually beat the 13th, 14th, and 15th Amendment, right?
You know, I see what Jonathan Marsh is asking there. You know, how's the 10th Amendment been able to use to justify limits on the Civil War amendments, which were state power? It would be better if I knew, like, more precisely what's being referenced there. But the basic thing I would say is that what we have is a tug of war between, you know, the Civil War amendments on the one hand, limiting what states can do, and the 10th Amendment empowering states, right? So, I mean, the basic thing you see there is a tug of war between the two, and we've been, as with so many constitutional tensions or contradictions, we've been working it out as we've gone along. So, so there we go. I think that's the best I can do with that one. Okay.
Yes, I mean, that's an ultimate question, but it may be, I mean, I'm guessing, not guessing, but, you know, it's my interpretation that, you know, it goes back to some of the questions or the direction of the questions that I asked, you know, earlier, that, you know, it was an imperfect union. It was a union kind of stitched together, that the states wanted to actually claim as many rights as they could. And even though you had the law, you still had political dynamics at stake. And sometimes, you know, the political dynamics, as we see today, you know, would defeat, you know, the federal constitutional kind of like amendments. And also because, you know, it's federalism. So there is a decentralization of power, which is like the very core of what the whole system was about. So let me go to the second question, Sarah Wilcox. Purposes of representation and taxation. I understand, I mean, this goes back to the founding articles of the Constitution when we mentioned the 3/5, right? I understand representation, but what is taxation? Enslaved people wouldn't pay taxes. Would slaveholders be taxed?
I believe that's right. That's a good question. I believe that's right. The operative section of the Constitution says in Article 1, Section 2, Clause 3, okay? Representatives and direct taxes shall be apportioned among the several states, which may be included within this union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years. So that would be like what, indentured servitude, I think, not the same thing as slavery. And excluding Indians not taxed 3/5 of all other persons. Okay, so it's a good question, and I'm clearly that, yeah, the taxes would not be imposed on the slaves themselves, that they would have to pay. But insofar as there would be a tax based on just the number of people in the state, I think that would be where it would come into play. It's a good question. That's the best I can do with that.
So, Ron Ludwig, didn't James Meredith integrate Mississippi before 1964 Civil Rights Act with the help of the federal government?
Good question. I don't know. I'm not going to pretend I know what I don't know. So I know it was at about the same time. So, but I'm sorry, I don't think I can speak with any expertise on that.
So then there's a question that I asked to put from the chat to the Q&A, and I don't have the name, so I feel bad that I can't quote the name. So you stated that at the formation of the nation, there were only bad options. The U.S. is a European settler colonial project based on slavery and genocide. Is it possible that for we whites, there were only bad options, but for Africans and indigenous people, perhaps their collective life would have been better if our, quotes, nation was not consolidated?
Yeah, it's a good question. And I don't know. Even professional historians, I'm not sure, can say for sure. My point is the following, and I'm willing to be talked out of this as a good liberal, right, in the political center. I just think that, you know, obviously the European powers in the late 1700s were much bigger and stronger than the scattered colonies along the Atlantic coast, right? And I'm willing to be talked out of this, but it seems to me that they recognize that if the colonies split into two or more separate, you know, countries, that would have been that much more enticing for some of the great European powers, including Britain itself, by the way. They were probably still kind of angry about, you know, having been kicked out, you know, to come in and try to take us over. And so that's my take. That's why I say I think there were only bad options. And again, I include among the bad options the option to preserve slavery. Nobody is pretending that that was a good option for the slaves. But I think that, you know, for a lot of the white colonists at the founding, it was almost a question of which do we opt for? Some of us are going to be slaves, or all of us are going to be slaves. Because if the big European powers had come in and taken us back over, I mean, who knows how any of the colonists would have been treated. But again, as a Socratic philosopher, I try never to pretend that I know what I don't know. And so I'm just kind of an amateur historian there, but that's my take. And so
yes, but I don't know that yes, I understand how you're framing. And if you look at the US historically, which is, you know, you have to frame the options at the moment they took place. Otherwise, yes, it's counterfactual history. And yes, we can, you know, aim for the ideal society, but no. But given the options, right. But I mean, in moral terms, since you're a political theorist, as I am, just to opt for the lesser evil, and in a lot of ways that the North has been presented as these, you know, good, equal, you know, it wasn't. I mean, right. It wasn't. First of all, because it compromised, you know, but second, because in the North, as in the South, there was, you know, separation, and there was a huge backlash. And actually, the first mention, you know, to that kind of separation, I have the quote somewhere. It was in a Boston Gazette about separation, right, in the North, not in not in the South, interestingly enough.
Okay. It's also worth noting, I think, that the North benefited economically from trade with the South.
Of course.
Yeah.
Of course.
So there was.
And you know, I was looking a little bit into the metamorphosis of the Republican Party, right? Because those in the North were the Republican Party, as opposed to, you know, the South, the Southerns, you know, supporting these measures that were Democrat. But it makes, I am saying something here for the sake of the conversation, right? But the Republicans were the party of business, right? And for business, you need to have independent mobile units. I mean, it's you know, the capitalism versus feudalism, if you want, like the slavery economy. So at the core, there was these contradictions, the tension of economic interest.
Yeah.
And they resolved this the best they could, but it was not because of these normative ideals of freedom and equality, I don't think. But that's my position.
I think there's a lot to that. Yeah.
So the relationship between Prop 209 and the Bakke decision. That's a good question.
Sure. Okay. Well, again, so the Bakke decision was a U.S. Supreme Court decision interpreting the Equal Protection Clause of the 14th Amendment. Proposition 209 is a very different form of law. It's an amendment to a state constitution. So just in terms of source of law, they're very different on that account. 9, again, I think it's fair to say that it made racial non-discrimination, race, gender, ethnic non-discrimination, the actual policy of California law. It's interesting. California Constitution also has an equal protection clause, right? That was already there in the buildup to Bakke, and yet, you know, public institutions were able to do things like set aside 16 seats out of every 100 at the UC Davis Medical School for people only of some races or ethnicities. And so that was going on, even though the California Constitution already had an equal protection clause. And so this is what made Proposition 209 possible. And Proposition 209 makes even clearer and more thoroughly than the California Equal Protection Clause that race and sex non-discrimination against any person is the rule.
Right, but yes, because I work in the drafting of the strategic plan for equity, diversity, and inclusion for UC Berkeley, you know, 10 over 10 years ago, and we were actually completely constrained, right, by Prop 209. And the discussion at the time was that, you know, the California Constitution had an equal protection, you know, clause, as you said, and the wording on the Prop 209 kind of added these like non-discrimination, whereas that the non-discrimination was already present in, you know, the California Constitution, because it wanted to make it kind of more legitimate vis-a-vis no preferential treatment. I think that the important language in Proposition 209 is not non-discrimination, because that was already present, but this is like a personal reading, but the preferential treatment. What are your thoughts about this?
Yeah, okay. Well, you can say that the Equal Protection Clause, which was already there, stood for non-discrimination, but it seems pretty clear that that was being ignored. Insofar as, you know, for example, UC Davis Medical School was setting aside particular seats only for members of some races or genders.
True.
Or ethnicity, race or ethnicity. So, see, the Equal Protection Clause was there, but it was not preventing discrimination. And so Prop 209 sought to clarify the rule. And so that's what I'll say about that. And so, by the way, in repealing Prop 209, by the way, we have to be clear that if Californians repeal Prop 209, they will be repealing non-discrimination. And when that repeal is challenged up to the US Supreme Court, that's going to be a tough case to make, right? I don't know how that's going to shake out. But again, if Californians repeal Prop 209 in November, they will be repealing non-discrimination. And I'm just not sure how easy that's going to go down, especially for some of the new members of the court, like Kavanaugh and Gorsuch.
Mm-hmm. So you think that by repealing, I mean, you have this double-edged sword that was very much built in. I mean, and since I do not see further questions, that I would be happy to bring the audience actually to ask you the question. But since what you're saying is so interesting, I want to ask you. So you think that, you know, this is a double-edged sword and it could be used, you know, to campaign not to repeal Prop 209, besides like the regular arguments about like individual civil liberties and merit accomplishments, but wouldn't be a counter argument that this time politically the equal clause would be able to make up for that non-discrimination repeal?
I'm sorry, Maura, I apologize. I'm not quite sure I understand your question. Could you
Right. So you're going to let's say, you know, there's a repeal of Proposition 209, like both in terms of non-discrimination and preferential treatment.
Okay,
So
it's
my
repealed.
question
You're saying if we repeal it.
Right.
If we repeal
Right.
it. Okay, go ahead.
So my question is, given that the political context has changed, right? In these last like 25 years, and you do have an equal protection clause, wouldn't you think that that would be enough to secure the non-discrimination or to prevent further lawsuits?
I don't think so.
Okay.
Before Prop 209, there's no question, public institutions were using race, ethnicity as a factor in allocating scarce benefits like public jobs and public contracts and public university admission seats. And so the Equal Protection Clause by itself of the California Constitution does not seem to have been ensuring non-discrimination.
But you are equating with what you're saying, like non-discrimination and preferential treatment, right? Basically race neutral.
Yeah.
Not because you are saying it, is because it's the understanding in the letter of the law.
Okay. Not sure how to answer that. That gets tricky. I'm just saying that the lawyers defending the repeal of Prop 209 before the U.S. Supreme Court 2 or 3 years down the road are going to have a very tough case to make.
Mm-hmm.
The court that Californians can, consistently with the 14th Amendment to the U.S. Constitution, repeal non-discrimination. You know, it seems to me one way at this is that if we really think that it's important, and a lot of good people think this, centers of power, both public and private, ought to be able to treat people differently based on race or ethnicity or sex, if that's what it takes to ensure proportional representation, right? So you hear about remedying underrepresentation, right? Remedying representation. Okay. Now, if that is held as a principle across the board, every race, every ethnicity, both genders must be, you know, proportionally represented in all, you know, public institutions, fine. Let us get rid of the Equal Protection Clause so that centers of power can discriminate in order to ensure proportional representation. That's a big step, and I don't know how many people would want to do that, but that's kind of the quandary that we're in.
Right, but proportional representation is not proportionality vis-a-vis past injustices. So it's just completely different. It's like a kind of horizontal sociological cut in terms of numbers to have, right, you know, understand representation in terms of numbers, but not in order to level the field and address, you know, past injustices, right, to have a bigger share in society. So it's just a completely different story. It would be more along like Rawlsian kind of lines. And I'm not disputing Rawls at all, but I'm saying like this wouldn't address what it is behind the repeal of Proposition 209, at least in political spirit.
Yeah. So you're talking more about the remedial rationale, not the
right, because that is, I mean, I'm glad you brought up, you know, kind of the word, because that is what it's at stake. I mean, it's not proportional representation. It is incredibly remedial, and this is kind of the other side of the coin of, you know, the Asian American lawsuit against Harvard. They're not looking at the remedial. They're actually looking at the other side. Like, look at the effects that this remedial is having on us, right?
Yeah.
So, oh, we have more questions.
Okay, bring them on.
So who's
Oh.
behind funding Prop 209? I don't have your Elizabeth. Elizabeth Frommer. Who's behind finding
Okay.
Prop 209?
Who's behind, so the second one by E. Helford, can you expound a bit about who is behind the repeal of Prop 209? I believe it is an organization called Students for, no, I'm sorry, that's Harvard. So who's before the repeal of Prop 209? Okay, well, I think those who are behind the repeal of Prop 209 are those who want public institutions to be able to discriminate. Good discrimination for good purposes, but to discriminate based on race, ethnicity, gender in, you know, the allocation of public benefits like jobs and university seats and contracts. So,
Yeah, so in California, the Green Lining, I think it's called the Green Lining Institute, is supporting the repeal of Prop 209, not only in terms of, you know, access to education, but also in terms of, you know, economic opportunities. And they're making like a strong argument that the communities that have been hit the most are communities of like Black, Latinos, women, and it's going to be a huge thing, you know, after COVID, how to reconstruct and give opportunities. So that's one organization strongly behind. The regents of the University of California have supported the repeal, have actually upheld before it was passed in the Senate.
really?
The repeal of Prop 209, but I don't know who's the formal instigator, to put it somehow. So who's behind, and who's behind funding Prop 209? I don't know whether you
I think
know.
you mean the repeal of Prop 209.
No, the Prop 209. I heard Connolly with Michael Krasny like strongly in favor of keeping Prop 209, but formally I don't know what money is behind the campaign.
Yeah, me neither. It's a fair question.
So no, that was Elizabeth. Can you expand a bit about who's behind the repeal and what their motivations? I mean, we covered some of that.
So a successful repeal. Next
go
one.
Ahead, go ahead, Marty, please.
Yes, a successful repeal of Prop 209 would in effect be a reversal of the Bakke decision. Yeah, in a sense, yes, sure. That's partly true. Much of it is true. Repeal of Prop 209 would enable, you know, say tenured, you know, faculty at University of California to use race as they see fit in admitting and denying admission to applicants. And that gets, you know, that's, and somebody actually mentioned this too. It's like the next point, good discrimination is an oxymoron. Why are you using that term? Yeah, you're right. I get it. I'm not sure. I think there's a thing is good discrimination. So I use it advisedly. But let me point something out here. You'll find this interesting.
But it depends on how you define discrimination, because, for example, Hannah Arendt.
Treating people differently based on race or sex. I think that's discrimination. You know, Mark, you may know that in the 1964 Civil Rights Act, Title VII, an exception to the rule of non-discrimination for what are called bona fide occupational qualifications, BFOQ, bona fide good faith occupational qualifications.
Bona fide. Yes.
Yeah. So, you know, so for example, a good example there would be, imagine that a senior citizen living facility that has mostly elderly women, they need to hire somebody to come in and do things like give them sponge baths. Now, an 85-year-old woman does not necessarily want to have a 25-year-old man giving her a sponge bath. And so for a job like that, it may very well be that gender is a legitimate qualification for the job, bona fide occupational qualification. But please notice that even though that's built into that law, that's the exception. The rule is discrimination. That's why when I say good discrimination, if I said that, I'm not sure there is such a thing. I think I agree with the premise of the person asking the question.
Yeah, there are qualifications. I mean, I think that we're gonna go off topic conceptually, and it's a highly controversial position. For example, you know, the one Arendt wrote in her reaction, Hannah Arendt, you know, the German political theory is too little rock, right? Like putting discrimination at the level of the social and not the political. But that would just, this is what I was having in mind. Happy to discuss it with you when we're done with this conversatory, because we have one more question and I
Yes.
want to honor the audience. So can you explain the new Department of Justice lawsuit against Yale? Is it different from the Harvard case?
Yeah, that's a good question. I saw that myself. I don't know a lot about it, but I did notice that the Trump Justice Department is apparently proceeding against Yale. And my understanding is that the theory or the claim is the same as in the Harvard case, namely discrimination by Yale against Asian American applicants. But again, that is the Department of Justice bringing the lawsuit, as opposed to a organization like Students for Fair Admissions, which brought the lawsuit on behalf of Asian Americans against Harvard.
Is this Ed Bloom behind the groups also in Yale?
I guess we're going to find out, because the Department of Justice has initiated this action.
Right.
So, yeah, so I'm just not sure. Maybe, the Trump Justice Department is doing basically this way, kind of what the Students for Fair Admissions are doing on behalf of Asian Americans with respect to Harvard. So that happens. If Donald Trump is defeated, though, in November, I'm pretty sure that this Department of Justice lawsuit against Yale is going to go away. Although obviously that would have nothing to do with the progress of the Asian American versus Harvard lawsuit that is already in the federal courts.
Yeah, that's, may I, before concluding, if you feel like it, no pressure, would you vote to repeal Prop 209?
You're asking me personally how I would vote? Oh my God.
But only if you want to share.
Okay.
You don't.
Listen, let me just say, I think that public institutions should not discriminate based on race or sex. And I think if they really want to do so, you know, based on proportional representation, okay, but make sure that you agitate to repeal the 14th Amendment. To agitate to repeal the 1964 Civil Rights Act. Because the 1964 Civil Rights Act bans discrimination based on race, gender, ethnicity against any person. That's either a principle that we embrace or it's not. And so I actually think that non-discrimination is a good rule. And that's to say nothing about, you know, say if I'm a university teacher, should I grade my students fairly based on their objective merits, or can I take into account their race or ethnicity or gender? I can't imagine doing that. I didn't get into teaching to do that, but you can see the position that somebody like me is in. Wait a minute, my government gets to discriminate based on race and sex, right? Because they're doing good things, but then I'm not supposed to discriminate. I'm not going to discriminate. You know, I was raised better than that, but it's a little bit disconcerting for public institutions to say to me, Carcieri, you have to treat people on the individual merits, but we can take race and ethnicity into account. And that's a liberal position. I'm in the liberal center, so.
No, I understand, and I like the fact that you end on a kind of like normatively consistent point that doesn't succumb to political entanglings, if I may put it that way. I create lots of new words, you know, no, but that's the dilemma, right? When you want to be consistent normatively, because if you don't level the field normatively with consistency, I mean, you're actually reproducing the same dynamics, right? Or creating tensions. On the other hand, politically, right? And I'm going to leave people with these perplexities because we're not going to have our next conversatory until after the elections. So we'll find out. Wow. On the other hand, if you don't take into account the political effects of what you're doing and redressing past injustices, you know, you're not actually solving the problems or fostering, right, a form of justice. Maybe not the ideal form of justice as fairness as you propose, but a form of justice or more justice. Yeah. So, you know, I like finishing on your, because then you have, you know, how you justify then implicit bias comes into the, isn't that implicit bias? Isn't that bias towards others? Is it positive? Is it negative? Why positive? Yes, negative, no, right?
Yeah.
How do you justify that on normative grounds?
right. It's an interesting discussion. And I must say, Maura, you're a heck of a wordsmith. Can I say that?
Not the first time I hear it, I have to say.
Good for you.
Anyways, Marty, this has been an amazing conversation. And I thank everyone for participating and for putting up with our, exchanges from political theories to political theories. Is professional deformation, probably. And thank you very much, everyone. Thank you, Derek. Thank you, the whole staff. Thank you, Marty. We have discussion session tomorrow. It's going to be from 2:30. We're going to have only one session. Derek might have already posted. And if you do not join the discussion session tomorrow, I'll see you for the beginning of part 2. We also have another set of amazing guests. So Marty, thank you very, very much. And thank you, Derek.
Thank you, Mara, and thank you, Professor Carcieri and Professor Kolesas. This was wonderful. Thank you. Have a good day, everyone.
All right.
Bye-bye.
Thank you, everybody. Take care. See you all soon.